Well, hello and welcome to this Professional Advisor webinar presented in association with IRESS, where we're going to be discussing what advisors should be thinking about and what they should be doing ahead of GDPR's implementation almost exactly 6 months from now. I'm Julian Marr, Editor of Professional Advisor, and today I'm joined by Chris Pitt, Head of Marketing Analysis at IRESS, John Salmon, Partner at Hogan Lovells in the IT Department, and Mike Barrett, Consulting Director at the Lancat. Hello everyone.
Good morning.
I think we'll start with a scene-setting question, and Chris, you get it first. What is GDPR? Why has it been introduced? Nice and simple.
Yeah, so GDPR is General Data Protection Regulation, and it's a piece of EU regulation that's been brought in to replace the Data Protection Act, largely because the Data Protection Act was introduced 20 years ago. Doesn't seem that long, but actually a huge amount has changed over that period of time, especially with the technology side of things. So it's really a piece of legislation that is designed to update things in light of that technology change and give better protections to the consumer.
John, it feels rude to say anything to add to that, but since this is your area of expertise, can you?
Yeah, I mean, I think I completely agree with Chris. I think it's reflective of us moving into the digital age, but I think it's also there were different treatments of the last data protection directive in EU law. So I think why a regulation rather than a directive is because it's intended to completely harmonise across Europe. So the idea, and this is quite an important one, is that there is a single law across Europe, so there's consistency across Europe. I think the other thing that it's really trying to achieve is more accountability on people that process data, that do things with data, and more transparency and control for the customers. And that kind of goes right through the heart of GDPR, and also leads to much bigger fines if there is a problem with the processing of data.
Okay, and Mike, I need to add, just from your point of view, where's it come from?
I think from our point of view, I would echo the comments about it's bringing data protection up into the digital age. So most people these days are glued to their smartphones, glued to their iPads, etc. And the amount of data which is accessible there is a real challenge, I think. And the legislation needs us to catch up with that, and this is what's coming through.
Okay, thank you. Now I should be saying, of course, that this is an interactive webinar, so please do send in your questions, as indeed some of you are. And I will say to our technology people, if they haven't noticed, that we're getting a couple of questions coming through suggesting that they can't get the event to start. So if everyone on that, just in case, thank you. Yes, we are. So we're hopefully getting to that with you now. I know we mentioned the existing Data Protection Act. What would be the differences between that and GDPR?
I think there is a few sort of key ones. Firstly is the scope of data that is included. The GDPR scope is around personal data, as was the DPA, but it's much broader. So for example, the GDPR includes data that is held on paper card records as well, which I think is quite a significant point. Mm-hmm. And also it extends really into different areas in terms of the scale of fines. I mean, at the moment, 500,000 is British sterling is the maximum fine in the UK, but that now has been increased up to 20 million euros or 4% of global turnover. So if you're the likes of Facebook with a global turnover of something like $27 billion, then you could be looking at a fine of up to $1 billion. So these are really, really chunky fines, and I think it is emphasising the point that the regulator that is really wanting people to take this very seriously at the end of the day is about personal data. And the final point I'd make about the difference is that you actually now have to demonstrate that you comply. Under DPA, right, you just had to comply, but now you actually have to be able to prove and demonstrate how you comply, which again I think is significant.
So really upping the game, John?
Yep.
Yeah, I think just building on what Chris has said, I mean, there is that concept of accountability, but I think there's also the concept of transparency for customers, and there's a lot more requirements on the controller to tell customers what data has been collected, who they're going to share it with, what they're going to do with it, and I think, but it also that they re-emphasises the rights that they have. So you have to tell them, for instance, about their right to data portability, the right to be forgotten, the right to rectification, and if you've got, if you're collecting and using that data from a consent point of view, the requirements for consent are much higher, and you have to re-emphasise the point that consent can be withdrawn at any time, which is actually, quite a big thing, particularly for, say, marketing, where you've got to make sure that they understand that they've consented, what they've consented for, and that they can withdraw their consent at any time, which does put processes in sharp relief, I think.
Thank you, Mike. We're going to.
Yeah, I think the only thing I would add is it's worth remembering this isn't just about financial services. So I noticed on Sunday Manchester United were advertising the need for their fans to re-register for their email alerts on a big banner ad in the middle of their biggest game of the season, which presumably is an expensive advertising slot for them to be taking over. So I think if your football club is asking you to reconfirm your permissions for marketing data, then most clients will be expecting their financial advisor to be doing something similar. So the general public are going to be aware about this.
I think that's a really interesting point, just to pick up on that.
Sure.
Because I suppose sometimes we think we can leave it and we'll send out emails, letters to gather those consents, but we have to realise that advisor businesses you'll be competing in a world where just about every other brand is doing the same thing at the same time. So personally, I'm feeling a little bit nervous about this, and I think my inbox could get slightly flooded with requests for regathering consent as to what I want to get emails as regards. So I think we would say we see that event coming up with more emails going out, so you might want to get ahead of the game and actually start collecting those consents sooner rather than later, whilst things are perhaps a little bit quieter.
Thank you. Well, speaking of flooded inboxes, we'll be definitely beginning to get some questions in, so thank you for all those. We will get to as many as we can, after I've done a few on my own, of course. And also, to keep the interactive element of this going, there are a couple of polls we're going to be running through the session. First one is about to go live now. The all-important question: how ready is your business for GDPR? So that should be up and running. If you can fill that in or just answer that question, that would be lovely. It'd be good to know. I'm going to move on to, let's say with the nitty-gritty now. Which area of GDPR are the most important for the advisor business to consider? So we're focusing on advisors now. Chris?
Yeah, I suppose there are a number of areas, but one I would particularly pick out is the actual hosting of your data. So if you're using a back office system, and I can't really see how an advisor firm can actually meet the requirements of GDPR without having some sort of system in place. But if you're using a hosted system, then fine, you'll have a good supplier there who is actually hosting all of that data in a safe, secure way, backing it up for you. But if you're self-hosting, then I'd strongly say, perhaps you ought to, make sure that you are containing that data, maintaining it and storing it. And if you, running it on your own servers, are they fully encrypted? If you take data out on laptops, again, make sure they're fully encrypted so that you don't fall foul in those respects.
Thank you. John, your thoughts?
I think the big thing is actually for advisors to understand what data they have, to the point that we just discussed, how it was collected, what they've been told that they can use that data for. So what data they have, and actually understanding your full data architecture, what your data flows are, who the data is going to, because you've got to tell the customer all of those things. But that is also reflected in these increased rights of customers that I talked about. So if you've got the right to rectification, if the data is wrong, or you've got the right to data portability, I think that's quite an interesting one. So the right to data portability is all around, within a month, you have to give all the data to the customer or their new supplier. So if someone decides to change your advisor, you're in that position where you'd have to get all the data, give it to them in a data readable format, and give it to either their new advisor or to them. So that's a reasonable challenge. You've got to know where the data is as well. It's got to be accurate. And then of course you've got notification of breaches. So you have to, one of the other things in GDPR that was long debated and was, so where there has been a serious data breach, you have to potentially notify the customers within 72 hours or as soon as reasonably practicable, without undue delay, is the exact word. So it's pretty that's again quite a difficult thing. So you've got to really understand, again, your data infrastructure and your technology infrastructure in order to be able to do that.
Okay, thank you. Mike, again.
Yeah, I mean, we speak with advisors pretty much every day at Blancat, and most businesses we chat with at the moment are in the fortunate position that the demand for their advice services has never been greater, and actually they're starting to look at kind of their operational side, so just simply so they can work with more clients. I think the GDPR actually creates there's a lot of kind of negative stuff here, but about kind of fines and breaches and all of that. But actually, there's quite an opportunity for advisors to sort out the data, which for most businesses, it's kind of a nagging doubt in the back of their mind. But as successful as they are at the moment, they could probably do a little bit better with some of their data management, and whether that gives them the ability to serve different client segments or just simply reduce the cost of delivering their advice proposition that they're doing at the moment. I think for a lot of firms, it's a chance to kind of build a better business as well as meeting the requirements.
I think we're going to get on to some of the practical points in a second, but just to touch quickly on the sort of the other side of the equation. What do you see as the key areas of GDPR that will most affect the clients? Say the average client, but there is no average client.
Yeah. Well, as we said, that area of consents, I think, will be the most visible, and certainly early on. So, the client will be receiving requests from all sorts of people in terms of, do you want me to continue marketing to you, and if so, in what particular context? That information has to be recorded and then adhered to in terms of going forward. So I think that is probably going to be the most visible thing. Yeah. But interestingly, I think another impact it will have, hopefully, is that the number of instances of misuse of data and data scams and things like that will actually go down. So hopefully, customers will benefit from there being less of those types of activity because more firms are actually controlling and managing their data in a more secure manner.
Okay, thank you, John.
Yeah, I think we've kind of touched on both of them, but I think the marketing permissions, you've got to get the permission from the customer to market to them, and that can be withdrawn at any time. So one of the things that you've got to think about is what is your process for doing that, because it's got to be a simple opt-out. So we're talking about the Manchester United thing, they opt-in, but you've also got to be able to manage your systems and processes so that people can opt out very quickly and easily. And it's because we have to tell customers in a much more transparent way what data is being collected, what it's being used for, how long it's been held for, who it's being shared with. I think that can be a very positive thing as well, but again, that's got to be presented in a very user-friendly way, and I think it should lead to exactly Chris's point of leading to a lot more transparent data culture. I think clients hopefully will see that as a very good thing, but you also have to back that up with your systems and processes. You can't just say, this is what we're doing. So you really do have to understand where your data is going, and I think it could lead to lots of good things because, people talk about data being the new oil, right? Yeah. And it having inherent value. And I do see that the value of data is only going to increase in the next 5 to 10 years, but you've got to think about looking after your data. So you've got to think about collecting it in the right way, processing it in the right way, and also making sure that it's not leaking out in the wrong ways. So looking after data is vital. Data governance is much bigger than just GDPR, I think.
Some of the conversations that we heard sort of around the industry is people beginning to question exactly whose data it is anyway, because we keep talking about the firm, it's your data, but actually I think we're moving to a world where actually it's the customer's data. They allow you to use it for a certain time, etc. And as John says, if they decide they don't want you to use their data any longer and they want to pass it to another party or have it back themselves, then they're quite at liberty to do that. So it's almost you're moving to a world where it's the client's data, you're a custodian of it for a period of time, so please look after it to the best you can.
Yeah, it's best to think it that way, isn't it? I mean, this feels to me like the switch from, as you said, the EU saying, no, it's not yours anymore, it is the client's. Is that fair enough?
Well, yeah, I mean, I have this debate quite a lot with people, so people
as your lawyer,
often...
it's nothing 100%,
well, people do stand up and say, we no longer own the data, and I think the use of the word ownership is, it does have a legal connotation, but I think also got an emotional connotation sometimes, so I think it's possibly unhelpful. I personally think that it's a move to more transparency and more control by the customer, but that's different from ownership, right? It's like anything, if you know where something is and you can control it and you can stop things happening, I absolutely, totally agree with that, and there's a move towards that. But I think ownership is something different, and I think, and this is what I mean by data. The whole data governance point is more than just GDPR. Part of it is about the contract that an IFA might have with a platform provider, or with a product provider, or with their system provider. Who can do what with the data is broader than just a GDPR question. There are still ownership rights on the data and other contractual rights and permissions that are actually relevant in this area.
Yeah, I think from an advisor's perspective, as we said, it's important to get to understand you're competing for airtime with, well, if your football club, the press, even leading investment consulting will be contacting clients to get permissions for marketing and communications, etc. So advisors need to anticipate that, need to perhaps look at different clients, have clients who they are formally engaged with and regularly speaking with, making sure that service can continue. Legacy clients perhaps, where you want to have the permissions to market to them in the future, you're going to need to get that into place before the 25th of May. And particularly also anticipating some of the provider communications which are coming out. So if a provider is going to be writing to your clients, trying to understand what it is they're saying and when they're saying, so that you can align your own advisor communications with that.
Okay, thank you. Now, no doubt most people watching here will have this under control, have a plan in place, and we're certainly not here to freak anyone out, but in fact we're here to help. If an advisor business hasn't got a plan in place, let's give them maybe a top 3 of priorities to get things going and sort things out in the next 6 months.
Yeah, I suppose I would pick up certainly on the points that John's been making. There is, you've got to start thinking about what data you really need to run your business, right. Getting that data architecture in place, and then I would say start to write down some processes. I'm sure lots of good advisor business will already have those in place, but I think certainly here there is an extra need to comply by being able to demonstrate that you comply. So yeah, question of documenting processes, procedures, and then maybe making sure that the staff who work for you actually understand and adhere to those particular processes. So it's probably quite a process-driven thing for me, but get the rules, create that plan, and start writing down your policies and procedures.
Would it help to have one person focusing on one particular, the GDPR champion?
I suppose if you're a large firm and you've got large amounts of data, then there is a requirement for you to have a data protection officer appointed. Right, sure. But I'm sure the majority of advisor firms would be small on that. But I certainly think it would make good sense to at least have roles and responsibilities. I mean, there is this requirement. If there is unfortunately a data breach, you have 72 hours to notify the regulator and potentially your customers as well. So the last thing you want is falling between the cracks at that stage. So yes, nominating and putting people in charge of specific areas of GDPR I think would make a lot of sense.
Okay, John, we're looking at the top 3.
Yeah, I think Chris is right. I think understanding your data flows, so one of the requirements under GDPR, if you drill down to it, is you should have a register of the data that you are processing as controller, and which third parties you're using to process that data. So you should have a register of all. So you've got to think about where's all the data that's coming in. And I was talking to the guys about it earlier on. I mean, the data that an advisor business has is probably relatively simple. You're probably not having that many data inputs, but there are some. There are a few, and then you're going to have your own service provider. So you just got to think about that. One of the other things that the GDPR brings into the law is something called privacy by design. So if an advisor business says, I want to move to a new digital platform or whatever, then they should actually do an assessment. So they should do a privacy impact assessment that assesses what effect is this going to have on my customers from a privacy perspective, and actually do a proper impact assessment. And I think the third thing is, depending on the size, you should actually think about roles and responsibilities, whether you need a data protection officer, which is a legal requirement depending on your size, and and who is going to be responsible for this. Because I mean, even in very large organisations, when there is, say, a data breach or a problem, there is usually quite a lot of running around trying to figure out who to contact and what to do next. So you should actually have a breach plan. I mean, that might sound completely obvious, but when there is a data breach, that this is who I need to phone, this is what we need to do, this is how we need to do it, because otherwise your 72 hours are going very, very quickly.
Yes, absolutely.
Yeah, and I think in our world of platforms, which we spend a lot of our time with at Blancat, I would extend this into how advisors work with and interact with the platforms. So most platforms are quite powerful pieces of kit these days where you can download pretty much every client's piece of data imaginable into a spreadsheet. So the potential for a breach there is quite high in theory. So from an advisor's perspective, what are the processes for username and control who within the business has usernames and passwords? If staff move on, if they leave the organisation, is the advisor on the hook to disable that access, or do they need to contact the provider? That level of functionality varies dramatically across different providers. So I think we would urge advisors to understand the processes and what they want to have in place, and to fit that into their due diligence and selection processes with their platforms to make sure they're selecting the best platform that matches their processes.
I think that value chain and due diligence is an important one, because it's not just the data that you use within your own business. It's if you share that data or pass it to any third party as well, you have that responsibility to make sure that they are doing it and they are complying with the GDPR as well. And again, if there's a data breach, that they notify you. So, I mean, for example, we're putting contract extensions in place to make sure that third parties that we use do notify us within the required time, so that we can actually comply fully. And it's not just you, it's your supply chain.
There's also, I guess there's also the point about what data you're actually collecting and putting in that system. You know, whether you actually have a legitimate ground under GDPR to process that data, whether you need to for the purposes. So, you know, there are various grounds legally for processing. One is consent, which we talked about, can be withdrawn at any time. But probably you may very well be using a legitimate interest ground, and you know, whether you have the legitimate interest to take all that data, put it in the platform, you know, whether that's absolutely necessary for servicing the client. You know, there's probably, you know, some debate around that. It's probably worth thinking about, you know, and that's where the privacy impact assessment comes in.
There's an interesting point about that in the right to be forgotten. As a client, I can say I want to be forgotten, but at the same time, advisors are required for other reasons to keep records. And so I think it's important that they understand and think through, actually, even if the customer asks me to be forgotten, on certain occasions I actually have to retain the data for other reasons.
Yeah, the right to be forgotten, and this is the point that we often talk about with clients, is not an absolute right. It is you have where you have a legitimate interest to retain that data, but almost certainly in your example, Chris, if I said to you, I need you to take out all my data, then you would say, no, I need to keep this for, say, audit purposes or for the regulator or whatever. But I could see, but what you need to make sure is you certainly weren't going to market to me.
No,
right?
absolutely,
And you might, you know, it may be that you don't need all of that data, so you might need to delete some of it. You know,
it's more factual, though. I mean, names, addresses, national insurance, and things like that. Would that be the sort of thing to be keeping?
Yeah, you would absolutely have to keep all that for the regulator's purposes. But you know, if there may be a whole bunch of other data, presumably that Chris has got in that example, that he doesn't need for the regulator, so you need to think about, and you certainly need to make sure again that the system is able to be clearly switched off for marketing, right? Because the last thing you want to do, because that would just irritate the customer, right?
Yes. And I think that's certainly something from a systems point of view that we've put in quite a lot of work into, is understanding all of those different possibilities and making sure that we capture permissions in a far granular level of detail than we ever have done before. Because as you say, I mean, in fact, the customer can request that his data is used for specific purposes and change those purposes as you go forward.
Yeah, change them any time, and the right to rectification, right to be forgotten, you know, right to stop the marketing. So there's a whole bunch of you're absolutely right. It is very granular, you know, and just making sure that you can enforce that, and again, that's a very deep understanding of where your data is.
Now, I'm looking at these questions that are incoming through, which I think is more questions than I've had in every other webinar I've done put together. So I'm not quite sure how we're going to... I will do my best to get through all those, I promise. And one way I'm going to do that, I suspect, is to start... feel free, obviously, to jump in wherever, but I'm going to pick on one of you and then move on if I don't get anywhere.
Sure.
So I've got one here, was what will happen if you ignore GDPR or miss the deadline? It's like playing chicken with the regulator now. So, John, maybe on that one.
I mean, it's a bit like MiFID II that we were talking about earlier on. You know, clearly there is a deadline. If I can't imagine the ICA is going to go around everybody that day and say, right, you're in breach, we're going to find you. But clearly it's not advisable to not comply with the law, and ignorance of the law, as we all know, is no defence. So, but you've got the fines Chris talked about earlier on. I can't imagine the ICO is going to be, trigger happy on day one, but all you need is a disgruntled client, right, or a data breach on day one. So I think start preparing now.
Yeah.
I'm this is, in many ways, it's an artificial deadline, but it is a deadline. So start preparing now and get it sorted.
As you said, I mean, he's not going to come around on the 26th and say start fining. But I suppose they are going to want to see evidence of if you've read, understand the regulations, and you're putting those processes and procedures, into place, and you're well on the way to doing that. But so I would certainly say don't ignore it, but I can't see big fines being handed out on day one.
I just got I can't do two things at once there. I got very excited. I've had more than 100 people have answered the first question, how ready is your business for GDPR? It's good that we're having this webinar. There's about a third of you said a plan and processes are in place, so well done. We have about 65% saying it's on the radar, but no plans yet. And there's a thin red sliver, which says I haven't thought about it yet. So that's 2% of you, very brave. But clearly you're tuning in, so you're thinking about it now. So I think that's a good start. So thank you for that. I'm just going to now publish our second poll. Are you confident your current advisor tech can help with GDPR? No idea where that's going with IRESS sponsoring this seminar. So let's see. Please, if we get a good response, that'd be fantastic. So I'm going to dive into these questions. I might have to pick them at random, please. There was a couple of. There's one here. How large must a firm be to have a data protection officer? And obviously, nothing set in stone here, but
there is. I can't remember off the top of my head. Actually, there's a.
It is set in stone.
Yeah, it is. Yeah, it's in GDPR. Yeah.
Okay, I think what we'll do is with these questions, as I think we'll let IRESS may well come back. Is that fair enough? And afterwards, and get in touch with those. So I'm not going to cut these ones out. How long can we keep an advice file if a client is no longer with us as a firm? With a firm, can we still hold information relating to recommendations should a complaint come in down the line?
Yeah, I think that's the question that we just answered. I think you'd have to speak. You'd have to speak to your auditors, make sure that you are keeping what you need to for the regulator, but no more than that. I mean, that was the point I was sort of making earlier on. There are data minimization requirements. So, certainly what GDPR emphasises that you shouldn't keep personal data that you don't need to keep for any longer than you need to keep it. And actually, one of the things that GDPR suggests is that you pseudonymize data. So you actually, attempt to, if you've got personal data you don't need, that you should make sure that it's pseudonymized so it can't be used.
And I think, as you said, John, there are a number of legal bases on which you can retain data. Consent is only one of those. Yeah. So there will be other reasons, legal bases on which you can store data.
But there is it's a legitimate interest is probably the one, but there's also legitimate interest is always balanced by GDPR. I think the interesting thing about GDPR is helpful for people to have in their heads is this is seen by the EU as a fundamental human right. It is a personal human right, and so often there is a balancing test between legitimate interest and that right.
Okay, thank you. Now another question. It's again on the policing side. Let's see if I can just find it. This is a new experience for me to have quite so many to be playing with here, so you can bear with me slightly. Who will police this in the UK, and what will that policing look like?
Yeah, so it's the Information Commissioner's Office. So they do it already. They're based outside Manchester, and they'll continue to do it. They've got a pretty big team there, so it will be them that you will have to notify if there's a data breach. Although if you're regulated by the FCA, you may also need to notify them as well. So if it's a systems and controls issue.
Just on the subject of the the ICO, there's quite a lot of information on their website, including a 10-point checklist of if you need to get started. So about 66% or whatever it was on the survey who are starting to get going around this. The ICO's website is quite a good place to start.
Yeah, it's a really good point. There's some, the stuff they produce is really excellent actually, and there's a whole bit on, the new definition of consent, for instance, and it's really well written.
When should we issue new engagement letters for our clients? Chris?
I think if you're looking for those consent, there is no reason why you can't start straight away. I mean, the rules are understood. So, as I said, for example, we've already entered into that sort of exercise, collecting new consents from our clients as a software provider. I see no reason why an advisor business can't do that straight away. Does anyone else?
I think you'd probably be useful to look at your data. I guess you've got to know what your data architecture is, so you can be granular enough. But absolutely, I think starting the process now, completely agree, Chris. I guess you've got to do that analysis of your data architecture, so you can tell them this is the data we're collecting, this is who we're sharing it with, this is what we're doing.
I mean, if you're going to recollect consents and then make sure they're correct for the new environment.
Yeah. I think the other thing that's interesting, and I suppose just to re-emphasise in terms of when in client communication, is that the kind of GDPR says that you shouldn't use consent where it's not proper consent. So consent has to be freely given, explicit, etc. But you shouldn't bundle it in with other terms and conditions. So if you have to consent to something, it's not proper consent, which of course sort of makes sense, right? But I think we're used to, in data protection land, asking people for consent, whereas there's much more of an emphasis on legitimate interests as being the ground for processing that I mentioned earlier on. So I think that's another thing to think about in your client calls.
Yeah. And I think it's worth just touching on that has to be explicit consent, doesn't it? We're used to sort of having, if you fail to tick this box, then you've given consent. And no, this has to be very clear, positive,
affirmative action.
Consent,
it has to be affirmative action, and and a proper consent. As opposed to well, I have to do it because I want to use this service.
Yeah. It doesn't have to be enthusiastic, really. Enthusiastic would be good.
No, it doesn't have to be enthusiastic.
Now, I've definitely say we were marketing this idea as being an opportunity or chore, but I think we know which side, and a lot of our questioners are coming down on here. I'm seeing the word threat once or twice, including. What would you see as the biggest area for threat in the financial advice sector? And we got the suggestion here is closed book pensions, where no interaction with their customers for many years. Does that sound possibilities? Are there particular areas of the advisors? Maybe Mike, what did you strike?
Yeah, I think that's we touched on earlier kind of the definition of legacy clients, and I think there's kind of shades of increasing grey around all of that. So it could be clients where perhaps there's trail commission which is still being paid out of the product, where by definition you haven't had any contact with them for a number of years, and that extends to the provider side as well. So it's extremely unlikely that there will be any sort of explicit permissions to the extent which we just touched on being talked about. So I think there is a fine line to tread between kind of getting those permissions in place versus kind of disturbing the relationship that may or may not exist with the client.
I think, as you say, I mean, it's terribly easy to sort of fall into the trap of saying, well, this is all about compliance and it's a threat, etc. I think there is a big positive upside here which we should take advantage of, and that's building that little word trust back into the industry. Is an opportunity for the industry and for individual firms to say, look, I really value your client data, the relationship I have with you, and I look after it securely, properly and well, and actually build that reputation for trust, because I think there is certainly that.
Yeah, I think inevitably in almost every advisor firm we know there's a segment of clients who are serviced more regularly and more frequently by the advisor, and there's another segment who are not. But GDPR will apply to all of these clients. You need to get those consistent approvals for all of them. So advisors, they can look at it as a threat. There's certain clients where they might lose that relationship with. They could look at it as an opportunity to build a relationship which perhaps hasn't been there for a couple of years.
And there is that sort of reputational damage issue. I mean, we think back to the likes of TalkTalk, £400,000 fine, but actually the reputational damage was probably far more than that.
Yeah.
And I think that's the key thing here is put these processes in place and avoid that, because the reputational damage, certainly going forward, I think, in an increasingly digital world of, I'm not sure I can trust that firm with my data, I think that's a big issue.
Yeah, and it does. And if you get your data governance right in the broadest sense that we talked about earlier on, then that does enable you to offer more digital services, presumably, and it does enable you to do other things that perhaps you're not able to do now because you don't know where all your data is. And I guess coming back to that legacy pensions point, if you're not marketing to them, then it's probably less worrisome, isn't it? You still need to know where the data is, and they still have the right to come and say, well, hold on a minute, I want the right, you haven't got my right name and address and all of that sort of stuff. But actually, in a world where we might end up with pensions dashboard relatively soon, that's probably a good thing, right? You know, because actually having an up-to-date address, etc. But I suppose you might not, I guess if they're in a closed book environment, you might not be wanting to market to them anyway. I suppose it does depend on what sort of client they are. And
Yes.
This is a slightly optimistic one, I fear. If we have obtained consent from a client in the past to contact them for marketing purposes, do we need to get permission from them again before 25th of May?
I guess it depends on what that consent looked like. And, you know, it's probably worth looking at the requirements. The requirements for consent, as Chris mentioned, are higher than they were before. They are slightly different, but if your consent was very good and there was affirmative action, etc., then... But one of the things that is good practice anyway is every year most people will go through their database and actually will kind of recollect, you know, and go through and send something out. You know, you probably often see that from some of your service providers.
Yeah, I suppose on a personal level, I'm quite looking forward to actually only getting emails from people who actually want to receive them from, and you know, there's quite a few that we get in our inboxes. We wish. Did I really consent to that? I really can't remember, and it would be good to actually...
And you're very cynical about using unsubscribe, aren't you? Or I am anyway, because I know if I always think if I click unsubscribe, then I'm more likely to get more crap from them rather than less. But
do you know, that had never occurred to me. I'm supposed to be the cynical one, Oops. Yeah, exactly. Thank you for that. I'm just thinking, I've got a few bits. This is... Are there any uses of data that don't need use permission from the customer? For example, sanctions checking of customers, which is also a legal requirement.
Again, that comes down to legitimate interests. So absolutely. So there's another ground for processing, which is for the purposes of entering into contract. So when you've got a customer coming in or a potential customer coming in, absolutely you would be doing KYC, AML, etc. So you could say that's in your legitimate interest or for the purposes of entering into this contract. So there are grounds, but at that point usually you'd want to also give them what would be called a fair collection notice, or saying this is the data we're going to collect and this is how we're going to use it, and be very clear and transparent, because you're probably going to want to use it for broader purposes than just that. But yes, you could.
Is there such a thing as consent in perpetuity?
Well, the point about consent, as I mentioned earlier on, is that you've got to A, tell the customer that consent be withdrawn at any time, and B, have the ability to actually do that. So, so yes,
in
I
theory,
suppose in theory, but
it's the customer who decides when it terminates. If they want to terminate it, they terminate it.
Yeah.
Right, now I've got through about 10 questions there, but I think I might go back to one or two here, but let's see if I can find it. There really are so many. Thank you so much for sending them in. But at the same time, forgive me for not getting around to all of them. I will probably add on a few minutes at the end to see if we can get a couple more. But I just thought here, one of our questioners who sent in a couple of questions also he's giving as well. They're giving as well. I think this is a good digestible summary of GDPR from the Irish regulator. We have http://GDPR and you. .ie / so GDPRandYOU.ie. There's another helpful hint. See, that's what we do here. We do helpful hints from everybody, from the audience, from our panelists. It's one of my questions. I think, Chris, this might be yours first of all. How important is it to have the right technology in place with GDPR, and how can it help?
Well,
what's the practical aspects of this?
As I mentioned earlier on, I mean, and as John's been saying all the way through there, it's about collecting the right data and storing it safely and securely. So I would say it's essential to have a technology solution in place, and obviously I think some technology solutions will help you more than others. We've been spending a good deal of time over recent months not only analysing the rules and regulations and designing solutions to enable data to be captured, but also talking to our users to find out from a very practical way of how do you understand that, how will you run your businesses, how do you want that reflected in for example, the permissions, as you say. I mean, capturing consent, but consent now comes in many different forms with lots of different permissions around that. So we've been, going through that, and as I say, I think the technology can enable the processes and procedures and the approach that as an advisor business would want to take. But ultimately, it's still back to the advisor business to say, how do I want to run my business? But I think most technology platforms, and certainly the IRESS platforms, will enable you to meet with those requirements and give, effect to the policies and procedures that you want.
Okay, thank you.
Yeah, I think with the amount of change which is coming through for this, and I mean, we thankfully haven't mentioned MiFID at all so far. The amount of processes and systems and controls which are required for MiFID, technology has to be the answer for an advisor business. I think it's difficult to imagine how an advisor could run their business effectively, and both from an operational side of things and from a risk management side of things, without adopting a back office system.
Is GDPR only applicable, I'm going back to my questions here, or still pouring in, it's actually, the screen's quite difficult to stay in one place. Is it only applicable to EU member states or the wider EEA area?
So it basically, one of the things it does is it does extend the sort of geographical applicability in the sense that it applies to any EU citizens, so processing of EU citizens' data. So it doesn't actually matter if you process it in the US, say, if it's concerned an EU citizen, then GDPR will apply.
So on my understanding, the likes of Facebook and like that, actually, it's used by lots of EU citizens. So although it's an American, based firm, absolutely it applies. So that's in terms of 4% of global turnover. That's an awfully big sum.
Okay, so yeah.
I know we've touched on the first half of this question, but I'm really doing for the second, just to sort of get that bit home. Do we need to write to our clients to obtain an updated consent? What if they don't respond? I mean, why do you keep banging your head against the wall?
Yeah, well, it's difficult. I mean, because you need that permission certainly for marketing, right? So you still got other grounds for processing the data for legitimate interest. So you can still. I think this is kind of important to keep in your head. You've got to. It's not just marketing. You do need permission for, but there are other, there are other things that you might do with the data, where it might be legitimate interest. So, but of course, people could then still object, right? So there's but I think it would be good. It's obviously you're going to have maybe 2 or 3 times to try and contact these people and actually say, look, this is what this is a legal obligation, and I guess it's about how you write to them as well.
Yeah. But ultimately, I suppose if they don't reply or they don't want to give that consent, then that's what it's about.
You'd certainly have to stop marketing to them.
You mentioned it's a bit like Beetlejuice. You mentioned MiFID 2, and here we go. There have been a few questions. I've been shielding you, but I think this one may sum it up because it gets to sort of compare the two, which I think is what thrust of one or two. A number of these questions have come in. Will MiFID 2 trump GDPR in terms of data retention? MiFID 2 states we should keep data, but GDPR states only as long as necessary. That actually that's rather good. That gets me about 6 questions in one there.
Yeah.
Thank you for that.
But and it's exactly the point again that we've I suppose we made a couple of times now, is if you've got legitimate interest to keep that data. So, for instance, for the legally complying with MiFID 2, then that's absolutely fine.
Yeah.
But again, not any more than you need to, and you got to think quite carefully about what data you need to keep and why you need to keep it and for how long. So absolutely, so there are a ton of reasons why advisors would want to keep data for quite a long time.
Yes.
in a long-term product, and that is entirely fine, and we're absolutely not saying that you should delete that data, but just willy-nilly keeping all your data forever without thinking about it and you don't actually know where it is not acceptable.
I think it comes back to that point, knowing what data you have and the legal reasons why you are keeping that data, and knowing under what conditions.
Yeah, you really need it's like what I was talking about earlier on. You need a register of the data you have. What do you have of customers? Where is it stored? What are you doing with it? How long are you keeping it for? Why are you keeping it? Because if there is ever a problem, a customer complains or the ICO comes to visit, then you need to have these answers.
been asked to repeat the GDPR, the IRESS regulator one. I'm still looking for it here. I'm not exaggerating the number of questions here, but I believe it was GDPR and you, so GDPR ANDYOU.IE. I think if you put that in, that will help out. We'll also make sure we put it on the articles we put in Professional Advisor covering this webinar. I'm also trying to find one that there was at least one question here that did refer to platforms, and since Mike's here and that's one of his most favourite things in all the world, what if a platform has a breach? Do we have to report this as a breach?
I think that will depend on the agreement which the terms of business which the platform will have with the advisor, and in terms of business the advisor will have with their client. I would imagine the client in that scenario will be getting a notification from both the provider and probably the advisor, if only just to manage the relationship.
The primary obligation would be on the platform, because the platform in that scenario is the data controller. So if there's a breach at the platform end, then the platform would have the legal obligation to tell the customer. But as you say, from a customer comms point of view, you'd want the advisor knowing about it as well.
Yeah, great news. That platform I selected and put you on has had a breach. Is not a good conversation.
But absolutely, it would be the legal obligation on the controller.
I'm conscious of the time here. So I'm going to try one more question here, then my wind-up question, then we'll see where the time is. We've got the apocalyptic. Is this the end of email as a way of communicating, collecting data? What do you think, Chris?
I'm not sure I would say that. I think as long as you follow the rules, I don't see a particular problem with that. I mean, I think there is an issue with secure emails, and I know from a technology point of view, we provide technology whereby advisors can notify a client that there is some information, but it's in a safe, secure place on our client portal, and we tend to do it around that way. So I think there's probably issues to be considered with how you collect that data, and we would always say it's probably better to direct the clients to a safe, secure environment, client portal, where they can enter that data rather than just collect it through the email. So if you guys have any other thoughts?
Yeah, I mean, email can be hijacked, right? So absolutely, I think that must be a better from a security perspective. But I mean, there's no reason why one can't use email, from and then, I mean, this is a discussion we often have with product providers and platforms. We're doing something digitally, so therefore we need to be super secure. And you can thinking, well, snail mail can, if you don't even know whether it's the right address, snail mail can go, easily awry.
Yeah.
Right. So if you send, I think actually email can be a better, more secure mechanism, but obviously email can be hijacked, as we all know. So it's just getting the right. I mean, Chris is absolutely right. Getting the right security in place and thinking about that.
Yeah. Thank you for that. I'm just looking at our second survey. They'll use a poll, which is annoying me because it's on 99. So if somebody could add in another one, that'd be fantastic. Vote one more time, please. In the meantime, while you're doing that, I'll finish with our final question. Thank you so much for all your questions. The fact that we have 50 so far, we can either be here until tomorrow lunchtime, or we'll find a way of sorting that out. And it's an amazing degree of interaction going on here. So I think rather than trying to pick any more for the time being, I may just admit defeat. But I'm going to ask this question, see what time it is. And this, just as a wind-up, overall, we came in deciding this was a chore versus opportunity rather than threat. Why does the panel think GDPR is an opportunity rather than a chore? Just that we're ending on a happy, aim for the happy ending here, Chris.
I think I'd sort of reiterate that point I made earlier on. I mean, you're going to have to comply anyway, but to be honest, that's not what it's about. It's about protecting us as consumers, and we're all consumers. So it's about protecting us, and I think if you're running a business, it's a great opportunity to clean up the data, put practices and processes in place, and be able to say to your customers, your data is safe and secure with me.
Thank you. Completely agree. I mean, knowing that you've got accurate data, knowing where it is and what you're doing with it has to be better. We made the point about operational efficiency, but you can also create innovative new products. And I absolutely agree with Chris, increasing that sense of transparency and trust. All of those things are really good things. So I don't think it should be all seen as a chore. I think it enables a whole bunch of new things, you know, around transparency, trust, but also just operational efficiency, and hopefully moving into a more digital, streamlined world.
Yeah, repeating what we've said, most advisor businesses are pretty successful at the moment, and but they've got this nagging doubt in the back of their mind that the data is not quite as efficient from their own perspective as they would like. GDPR is the chance, the opportunity to sort that out.
European Union help you to clean your house. Fantastic. Thank you so much for the response that has taken us well over 100 for our second survey. That makes me feel a lot better. So what the questions were, let's look at this one. We had to choose between, are you confident your current advisor tech can help with GDPR? 78% said yes, 22% said no. There's opportunities for everyone here. Otherwise, I'm going to wind up. As I say, this has gone on a bit longer than I normally like to hear, but there was so much response, I thought that was the right thing to do, so I'll wind it up on 50 minutes. I guess whether we respond to your questions, we have your email addresses. I need to check what the consent was beforehand, before we reply, but presumably, maybe there's an implied consent that if you ask a question, you want an answer, and maybe we can get the good folk of IRESS and Hogan Lovells and the Landcat to respond to those in due course. They haven't promised that. They certainly haven't consented to that, and enthusiastically or otherwise, before we do this, but we'll see what we can do, because there was a lot to digest. I know I only scratched the surface. Sorry about that, but I swear there were more than 50 unanswered questions there, and as I say, we would have been here until GDPR came in, which would have helped no one. So just leaves me to thank all our excellent panelists who worked really very hard today. Thank you to Mike, thank you to John, thank you to Chris, and of course for you taking time to watch this. We hope we will have some assistance. Thank you very much for watching.